because it brings up some interesting legal issues. All right, let's go on the record on, Tony, are you ready?
I'm ready, Judge.
Let's go on the record on DC 231565, Curavilla versus State Farm Lloyd. Counsel, make your appearances.
Yep.
Max
Ben Crowe on
Moran
behalf of the plaintiff.
Movement.
Let's try with the movement first. Who's the movement?
This is Max Moran on behalf of State Farm Lloyd's, the movement here.
Okay.
And Ben Crowell on behalf of the plaintiff, Susan Curavilla.
All right. Why don't we go ahead and proceed?
Thank you, Your Honor. We're here on State Farm's motion for summary judgment. This case involves an insurance claim submitted by plaintiff to State Farm under her homeowner's insurance policy. Plaintiff submitted the claim seeking coverage of damages to her residential property due to a storm back in April 2021. State Farm received the claim, began its investigation. That investigation included an inspection of the property by a licensed adjuster on behalf of State Farm. Shortly after the inspection, State Farm provided plaintiff with a copy of an estimate for covered damages observed during its inspection. Plaintiff and her roofer disagreed with the amount of State Farm's estimate. They requested a reinspection, which State Farm didn't see the reason to do at that time based on the information presented. Plaintiff ultimately retained a public adjuster, and State Farm did conduct a second inspection with plaintiff's public adjuster present. However, the amount of the loss after that second inspection remained below the policy deductible, so no payment was due or issued on the claim. 4 months after that, State Farm received a pre-suit demand letter from plaintiff's counsel alleging violations of the Texas Insurance Code and the DTPA. Plaintiff demanded State Farm pay $23,000 approximately in damages to the property. And then when State Farm declined to issue that payment, plaintiff invoked appraisal under the policy, which, as I'm sure you're aware, Your Honor, is a provision under typical insurance policy that allows for the parties' chosen appraisers to determine the full amount of the loss should the damages be covered. The appraisers did not agree, so an umpire was brought in. The umpire issued an appraisal award, and State Farm paid the full amount of the appraisal award. This all happened before plaintiff filed suit. Now, at the time State Farm paid the full amount of the appraisal award, they also issued an extra payment to cover any potential Prompt Payment of Claims Act interest that plaintiff could conceivably allege to be owed. So at this time, Your Honor, there are no additional policy benefits that could be owed here, and State Farm has already issued payment for any interest.
Mr. Moran, I've read everything, and so I'm familiar with the background, but I appreciate you telling me that. It seems like there's a big disagreement about this recent case out of the Dallas Court of Appeals. That's really what I'm gonna. You seem to say that this case is right on point, and so I'd like to see this case.
Yes, Your Honor. The Rosales opinion that you're referring to came out in May. It is directly on point. It's the exact same type of situation where we have a Windtail insurance claim and the insurer paid the appraisal award plus any interest that plaintiff could conceivably allege to be owed. And then plaintiff sought to continue the suit merely to recover attorney's fees. However, the Dallas Court of Appeals 2 months ago completely foreclosed all of plaintiff's arguments in Rosales, and those are the exact same arguments that are made here by plaintiff. That case is directly on point, and I don't see anything that could distinguish the Rosales opinion from the case at hand. The legislature has specifically set up a formula for the amount of attorney's fees that could be owed, and that formula, once you solve it, it results in a $0 attorney fee award for plaintiff. So there really are no damages in this suit that plaintiff could recover. There's no policy benefits owed. State Farm has already paid any potential PPOC, and there are no attorney's fees owed based on this formula. And it's easier to show you, Your Honor, the formula in the statute. If I can share my screen, I can show you the Rosales opinion.
Sure.
Could you please let me know, Your Honor, when you can see that?
I can see it.
Okay, this is the Rosales opinion from May 16th, 2023, and I'll scroll down to their discussion on Chapter 542A's formula for calculating attorney's fees. And in that formula, in order to determine if plaintiff can recover any attorney's fees, the amount that may be awarded to a claimant in action to which this chapter applies, which this chapter does apply to a Wynn insurance claim, is the lesser of, and then under A3 here, you would divide the amount to be awarded in the judgment, which in this case, that would be 0 because State Farm has already paid all policy benefits that could be owed. And then you would divide that by the amount alleged to be owed on the claim. But once the numerator is 0, Your Honor, it doesn't matter what the denominator is. The result is going to be 0. There are simply no attorney's fees to be owed here. And if I could scroll down, Your Honor, when you're finished reading, I will show you what the Court of Appeals said about this issue.
Go ahead.
So under C here in the Court of Appeals opinion, their aptly titled heading, in this case, the insurer's preemptive payment of the appraisal award eliminated the insurer's ability to collect statutory attorney's fees. And just like in this case, Your Honor, Rosales conceded that Chapter 542A applies to the claim since it is a hailstorm claim. And then, like this case, Rosales also did not dispute the insurer's assertion that it already paid the full amount of the appraisal award and an amount sufficient to cover any interest that could be owed under the PPOC Act. And like in this case, Rosales disputed whether the preemptive payment by the insurer would bar him from recovering attorney's fees. Now, just like this case, the insured relied heavily on Barbara Technologies, a case that the Court of Appeals distinguished. Now, in Barbara Technologies, the Texas Supreme Court held that payment of an appraisal award alone does not preclude a claim for prompt payment of claims interest that could be awarded if the insured later proved that the insurer violated some deadline in the statute. Like in this case, Rosales asked the court to extend the holding one step further, and the insured argued that the payment of an appraisal award and any possible interest does not preclude a claim for attorney's fees. However, the Court of Appeals in Rosales determined Barbara Technologies was not decided under Chapter 542A, which is the statute that includes the attorney's fees award formula, and that's how they distinguished it. They then go through the formula and talk about how it applies to Rosales, which is the exact same type of case as this with the same circumstances. And like our case here, Allstate had already paid the appraisal award. That's the maximum amount of policy benefits that the insured could be owed. So there are no additional policy benefits owed. Now, they plug that into the top of the formula, and the amount to be awarded in the judgment to the insured for his claim would be $0 in the numerator. And because the amount of attorney's fees is a multiple of that amount, Chapter 542A's formula must result in an award of 0 attorney's fees. It's the exact same case here. Rosales is not distinguishable in any regard to this case on the important factors. The Court of Appeals opinion here, they just follow the statutory language. They plug in the numbers. The amount to be awarded is 0. There are no attorney's fees to be awarded. There are simply no damages left in this case for plaintiff to recover. Now, plaintiff has argued that because some interest could be owed, that does not completely foreclose all of plaintiff's claims and that plaintiff can recover attorney's fees. However, the Dallas Court of Appeals here in Rosales says the existence of statutory damages for interest does not affect Chapter 542A's calculation of attorney's fees. It doesn't matter if plaintiff could be awarded PPOC interest in the calculation for attorney's fees. And plaintiff hasn't argued in this case that State Farm's payment of any potential PPOC interest was low, so there is no disagreement as to the amount of interest that could be owed. And here, it's already been paid. So there will be no judgment of any amount other than $0 of PPOC interest. There will be no judgment of any amount of policy benefits because the appraisal award has already been owed. So any judgment in this case, even if State Farm was found liable and that all of the damages in the appraisal award were covered under the policy, the judgment would be zero. Therefore, based on the statutory formula, the judgment zero, there is going to be no award of attorney's fees. Now, the conclusion of this, Your Honor, to wrap it up, the Rosales opinion here sums it up nicely. They state, ultimately, Allstate paid the amount of the claim as determined by the binding appraisal process. Allstate had also paid the maximum amount of interest owed as statutory damages under the Texas Prompt Payment of Claims Act, and the reasonable and necessary attorney's fees are zero as calculated by 542A's formula. Therefore, there are no damages here. Rosales could not recover any more damages, interest, or attorney's fees on his claim. And therefore, the Court of Appeals already decided this issue, already concluded that the insurer, in the exact same case we have here, was entitled to summary judgment.
All right. How do you distinguish that, Mr. Crowell? That does seem kind of on point.
Yes, Your Honor. I don't necessarily argue that Rosales isn't on point. I don't think that's probably the way forward overall. I think first and foremost, the background to Rosales is important, right? Obviously, the Texas Supreme Court decisions in Barbara Tech, in Ortiz, in Hinojos, all set the stage quite clearly that up until this new line of 542A interpretation, there's really wasn't a debate. The Supreme Court solved it, that these cases weren't over, right? You can't just go through appraisal, which was the intent initially of the insurance companies. Certainly Allstate, State Farm is kind of the kingmakers, if you will, on whose name appears on all of the case law that's being cited, right? So these attempts had been made over and over and over. I think now what you're seeing is within the advent of 542A, specifically 0.007, I think we're now seeing that attempt under the numerator be codified into Rosales, and there's indisputable, I believe, it's pretty clear the courts are split. There's no, and as cited in our response, there's no short of 5 federal courts, including Judge Garcia, who probably opined outside of the opinion in Rosales the most, I think, as to the specific issue regarding 542A.007 and the calculation method. I think he called it the numerator denominator argument, which I'm kind of not really a math guy more than anything. I'd like to stay in the English realm if I could. I think, in short, you've got all these federal courts that have ruled against State Farm's position in this case. There are certainly, undoubtedly, admittedly, some that have ruled specifically the Rosales opinion. I think is probably the largest of the one that is pretty on point.
Yeah, I'm a civil district court in Dallas County. I've got to follow whatever the Dallas Court of Appeals tells me to follow, and so the federal courts at this point are kind of irrelevant. If this applies and this is the law I have to follow, I don't see the path forward for your client unless you can tell me that somehow this case is distinguishable.
Well, I believe it is. I think, it is in one sense. I mean, the facts are very similar. I think the difference in what State Farm is trying to argue, what they want the courts to decide, quite frankly, with all due respect, is a pretty impressive sleight of hand. I mean, they make this payment and then they go out and they say, well, hey, look, we're not liable for it. right? We're not liable for it. And that's important. That's not that's not for nothing. They do that on purpose. It's throughout their motion. It's in their reply. And the reason they're not liable is because they know that if they're liable, the prompt payment of claims makes it pretty clear they owe the actual damages, they owe interest and attorney's fees. Well, we don't owe interest. We don't owe interest. They said that 4 times in their motion, right? Well, why? Why do they keep saying they don't? If they have this King's X, why don't they use it? We're liable. Here's your payment. Go away, right? But there's a reason they haven't. And the reason they haven't is because I think, first and foremost, the politics argument here, the legislature argument, the intent of the statute, which I think, to be fair, Barbara Tech, Ortiz, and Hinahos discuss a lot. I think what you're seeing, the real issue now becomes, what is the numerator denominator, right? They can't go out there and say, we're not liable, we don't owe this. First and foremost, a trial should go forward to prove liability. I think that was one of the clear takeaways from the Supreme Court trio of cases, if you will, Your Honor. I think taking that a step further, how do you look at the numerator denominator issue? I think, to be fair, the amount to be awarded, and I focused, when I read everything again this morning, Your Honor, I read their motion and their reply. What stuck out to me was actually looking in their reply with the 2 potential conclusions, right? Their argument boiled down quite simply is, if you look at the 2 conclusions, what can happen if a trial went forward, right? If a trial goes forward, number 1, they said there's 2. Number 1, in the first instance, there's a finding from the jury that their pre-appraisal determination, which was less than $3,000, is correct. And so as a result, the case is over. That's probably true. I think that's an estimate that was written, that they adopted as their position. I think when you factor in the depreciation that was taken out, fair enough. That's probably correct. Now, I don't agree. I think that at the end of the day, that would never come in. I don't think they get the opportunity to put forth that evidence, but if you could, I think that's probably a fair interpretation of a $0 award. Now, under their second conclusion, what everyone keeps saying is that the denominator number is 0. Why would it be 0? Is it 0 because they're not liable for the $10,900 and change that they owed?
I think they're saying the numerator is 0, not the denominator, right?
No, Your Honor, I'm saying
That's
what their reply says the award is 0 because we paid it. They're arguing a credit and an offset. Well, that's not true. The credit part may make that number go to 0 as far as, hey, we don't think we owe it, but that's not what the judgment is. It's not what the verdict is. The verdict is proving liability on their appraisal award amount, which I don't know if they believe they owed it or not, but they paid it. Right. So, I mean, Judge Garcia talked about this extensively. I'd be happy to pull it up on my screen. He's got a paragraph in there where he specifically addresses this, and his whole argument, which I think is well, the verdict number is not 0. It's the appraisal award. That's how much they owed. Right. So it's not a 0 calculation. It's not that they didn't owe anything. It's not like there wasn't wind and hail damage, a covered cause of loss out at this property. There is. But again, why does State Farm keep saying they're not liable if they have this King's X? Because they are liable. And if you proved liability, which is the point of the trial, the jury award is not 0. It's not 0. It's $10,900 and change, the amount of the appraisal award. And so that number would be the number you would use. It's not 0. It's the amount of how much they owed. So a $0.
Your Honor, the statute doesn't use the word verdict. Mr. Crowell keeps pointing to the verdict may not be a $0 amount. But the statute doesn't use the word verdict. It uses the word judgment. And that's why the Court of Appeals made the decision that they did, that the numerator would be 0. There are no policy benefits owed. There's no interest owed. Therefore, the judgment would be 0.
If the payment that they made was to satisfy the appraisal award, then they should say that. And they expressly don't. They keep saying it's not for that. It's not for that. Why? It's not for that. Why? Well, the answer, I think, to me is pretty clear. Because if they're liable for that money, they're liable under the Prompt Payment of Claims Act. And if that number, the amount they owed for that, how much were they wrong? That's the point. We're trying to encourage the prompt payment of claims, right? And again, Judge Garcia's, I think his opinion is pretty clear on that. There's no indication that the Texas legislature intended to read out attorney's fees for all practical purposes. Right. This is the same argument that was Barbara Tech, Ortiz, not in a numerator issue, but it's the same idea. It's the same thing they're trying to accomplish. If that was the purpose of the statute, they could have done it. The actual title is the prompt payment of claims, encouraging insurance companies to pay claims promptly. Right. And the actual award would not be zero. It wouldn't be. And they haven't accepted liability, they haven't admitted liability. And there's a reason, Your Honor. And I think that reason is pretty clear that if that's owed, if it's owed, then that's the number that you would have to use, $10,900. And they just, for obvious reasons, I think they won't do it. If they say it's owed, then what are we arguing over? Nothing. There's no trial anymore. It's an actual damages awarded to the plaintiff of $10,900.
Brief reply, Your Honor.
Yeah, I'm not sure I followed that, but okay.
I didn't hear anything in there that was distinguishing Rosales from the current case, Your Honor. All the arguments made by plaintiffs in this case were the exact same arguments, specifically identified, considered, and ruled on by the Dallas Court of Appeals. They were simply following the statutory language here, plugging in the numbers, and coming out with the conclusion that $0 are owed for attorney's fees after full payment of an appraisal award, plus any interest that could be owed. All of the legislative background arguments, all of the fairness arguments that plaintiff is making here, those were already considered by the Court of Appeals in Rosales, and those have already been determined. There was nothing distinguishing in Rosales to this case. We're in the exact same situation as Rosales, another case handled by our firm, Your Honor. And the few 3 to 5 federal district court opinions that plaintiff is referring to here, those were also dissected in Rosales. Meanwhile, Rosales points to 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 recent federal district court cases that decided opposite, including in the Southern District of Texas, where one judge has gone the other way, like in the case referred to by Mr. Crowell. The other judges in the same district have disagreed with his opinion. It's certainly the minority opinion here that plaintiff is pushing. And all of those cases were decided prior to Rosales. So Rosales had the opportunity to consider all of those federal district court cases, as well as any Texas cases, and make the decision that they did on the exact same case that we have here. There's nothing distinguishing. Your Honor, also mentioned in our reply is another recent case, the Fort Worth Court of Appeals on July 6, 2023.
You don't need to talk about the Fort Worth Court of Appeals. All I care about is the Dallas Court of Appeals. So, I mean, let me just say this. I've let you guys argue for a while because I think it's an interesting case, but I see the policy concerns, Mr. Crowell, that you're identifying, which is, I mean, fundamentally is that you want to encourage insurance companies to promptly pay claims. The system that has been created here doesn't do that in the long run because, you know, people are going to, if they have attorneys pushing them, they'll go through appraisal, and then eventually the appraisal will get paid. There's kind of this now get out of jail free card that allows them to pay the appraisal plus the interest and get out of attorney's fees. I personally have kind of a problem with that because eventually attorneys are going to stop pushing these cases because they can't make money on them. And then insurance companies will have no incentive to actually pay these claims. I have a serious problem with that. I don't think that's good policy, but I think the Dallas Court of Appeals, based on the statute and on the prior case law from the Supreme Court, came to the right legal argument based on what the law is, according to the Supreme Court and the Texas legislature. Isn't good policy, in my opinion, not at all. I have to follow the Dallas Court of Appeals. I may agree personally more with Garcia. If the law was according to me, I think I would probably go more into Judge Garcia's, but I have to follow the Dallas Court of Appeals. I see no way to distinguish Rosales from this case, so I unfortunately have to grant summary judgment. All right, guys. You have a great rest of your day.
Thank you, Your Honor.
Thank you, Your Honor.
And I'll be sending, I've signed the order now and sent it to the clerk's office.
Great. Thank you, Your Honor.
All right. You have a great rest of your day. All right. There's a gentleman here, Mr. Yeah. Mr. O'Cauley, what are you here for? We can't hear you. You're muted, sir.
Good morning, Your Honor.
Yeah, what are you here for, sir?
I had a court appearance today by 9 a.m., but I went to the court premises just to be told that it's only on Zoom. So I have to drive far back from home, from court to home. So that's why.
Yeah. Well, what's the cause number on your case so I can look it up for you? It'll start with DC.
Case number is DC 23-03045.
All right, let me look it up. I'll look it up on my system.
Okay. DC 23.
I got it. Give me 1 second, okay?
Okay, sir.
Is this O'Cauley versus Oloyish Misi?
So yeah, something or yes, Your Honor.
All right, let me see real quick what hearing you're talking about. Okay, so I think there's been a bit of a misunderstanding here. So yes, originally there was a hearing that was set on this case for today. That hearing was canceled because the defendant filed an answer in this case. And so there was no need for you to sign on. We need to go ahead and I'm going to note that we need to set this for trial. Do you not have an attorney, sir?
I don't, sir.
Okay, I'd encourage you to get one if you can. The other side has a very, very good attorney on the other side. So you want to try to find a good attorney to help you. We're going to go ahead and set this for trial. Let's see. All right, we're going to set this for trial on December 12th of this year. So you should be getting a notice out about that.
Okay, Your Honor.
All righty.
Yeah. So December the 12th, at what time?
At 9 o'clock.
9 a.m. again. Is that an appearance or on Zoom again, Your Honor?
That will be that will be in person.
Okay, Your Honor.
All right. Sorry you had to show up. In the future, if you're not sure about something, just call my court coordinator, Rhonda, and she can tell you if you actually have to show up.
Okay, Your Honor. Thank you, sir.
And try to get an attorney, okay?
I will.
All right. Have a great rest of your day.
You too, sir.
Okay. All righty. Is anyone here on Rodriguez versus Spivey?
Brennan Clay for the plaintiff, Your Honor.
Christopher Lawless for defendants, Your Honor.
Okay.
Behalf of Fluid Market.
I'm sorry, say that again.
Stephanie Earhart on behalf of Fluid Market.
Okay. Tony, let's go on the record on DC 22-16377, Rodriguez versus Spivey. Counsel, make your appearances.
Brennan Clay for the plaintiffs, Joe Rodriguez and Alvin Ogilvie, Your Honor.
Christopher Lawless for defendants, Antravius Spivey and CSB Logistics LLC.
Stephanie Earhart on behalf of Fluid Market.
Okay, this is one of these new motions to bifurcate under the new trucking statute.
Yes, Your Honor.
All right, is there, I didn't see any opposition by the plaintiff. I don't really know if there is a way to oppose those, so is there any opposition by the plaintiff?
Yeah, Your Honor. And just to clarify, I'm not opposed. I think they're entitled to a bifurcated trial. The order that they had sent over to me, I did have some issues with it. It doesn't lay out some of the exceptions included in chapter 72.053 and 054. And I thought it was a little bit overbroad the way it was written. A lot of times when I'm getting these orders on these motions to bifurcate, if it's just a simple one saying, in accordance with chapter 72.052, I'm not really opposing them. This one, I just think that the order that they'd submitted was a little bit overbroad. And so I wanted just to be clear with the court and at least have an appearance here so we can discuss what the terms of the order are and make sure they're in compliance with the applicable law.
Response?
Your Honor, I don't know exactly what his complaints are to the order. If he could be more specific, I could respond. Right now, I think the order is good as written, but I'm happy to.
Let me go ahead and share screen the order and we can kind of talk through it. I think that might make this a little quicker. Is this the order you're talking about?
That's the one, Your Honor.
All right, so what is it that you're concerned about?
So the first three paragraphs I'm okay with. When you get to that fourth paragraph, it is further ordered that the first phase will be limited to determine the liability for 1, the negligence asserted against defendant Antavius Spivey, 2, the negligence asserted against defendant CSB Logistics, LLC, limited to the negligent training and supervision claims, and 3, the negligence against defendant Fluid Marketing. I think it's a little bit overbroad as written because it doesn't include the exceptions that are set out in chapter 72.054. If I can share my screen, Your Honor, there are some exceptions set out on this on what you can get into, what you can't. And so I don't want it just to be read as a general order precluding things, because you are entitled under the statutes to get into things like whether the driver was licensed to drive the vehicle at the time of the accident, whether he was disqualified under 49 CFR section 383.51. Those are matters that are specifically set out in the statute that are to be addressed in the first phase of the trial. And so to the extent it reads a little bit over broadly that, only direct negligence claims are assertable in the first one, you are entitled to get into some of these issues in the first phase of the trial. And so I wanted to make sure that that was clear with the court and clear in the court's order.
Okay.
If I may share my screen, Your Honor, I can kind of pull up the specific language, I guess, that
Sure.
we're on that. All right. The court's on my screen.
Yeah.
Okay. So I guess under chapter 72.053, it does provide that in a civil action under the subchapter, evidence of the defendant's failure to comply with a regulation or standard is admissible in the first phase of a trial, bifurcated under section 72.052, only if in addition to complying with other requirements of law, the evidence tends to prove that the failure to comply with the regulation or standard was a proximate cause of the bodily injury or death for which damages are sought in the action. And 2, the regulation or standard is specific and governs or is an element of a duty of care applicable to the defendant's employee, or the defendant's property or equipment when any of these is at issue in the action. And then under chapter 72.054, in a civil action, which the employer defendant is regulated by the Motor Carrier Safety Improvement Act of 1999, party may present any of the following evidence in the first phase of a trial that is bifurcated under section 72.052, if applicable to the defendant in this action. And it goes to whether the employee operating the defendant's commercial motor vehicle at the time of the accident that is the subject of the civil action was licensed to drive the vehicle at the time, was disqualified under this provision of the Federal Motor Carrier Safety Act, was subject to an out of service order, was driving the vehicle in violation of a license restriction imposed under 49 CFR 383.95, had a certificate of a driver's road test, had been medically certified, was operating the vehicle when prohibited under 49 CFR section 382.021, 382.205, was texting or using a handheld mobile device, provided the employer defendant with an application for employment as required by 49 CFR 390 1.21A, if the accident occurred on or before the first anniversary of the date the employee began employment with that employer defendant. And then I guess also whether the defendant employer allowed the employee to operate the commercial motor vehicle on the date of the accident in violation of 49 CFR section 382.201, 382.205. So, to the extent that the order is overbroad and saying, okay, only the direct.
Yeah, I totally see what you're saying. The order does seem really overbroad. Do you have a form of order that you've used in other cases on this issue?
I do, Your Honor. Generally the way I've addressed this in the past is that, it's only really recently started coming up for me. A lot of times I'll just say, the trials are ordered bifurcated under sections 72.052, and that's basically the extent of the order. And then I guess we're planning on having a second hearing at some point in time, once we've had ample time to conduct discovery as to which of these specific exceptions to that rule would come into play. In this one, they have to file these motions within 120 days of the answer date. And so, I think we're probably still pending some discovery to figure out which ones might be.
Let me just find out the opposing side is in opposition to structuring the order in that way.
Your Honor, I'm not opposed to restructuring the order. This is truthfully the first order I've written on this new bifurcation type law. So if we need to narrow it down and address these exceptions later as they reveal themselves in discovery, I'm happy to do that.
Okay, why don't we do this? Mr. Clay, why don't you prepare the order on this? The notations in the file on this will indicate that, let's see, this is DC 2216.377. It will indicate that this case will be will need an order submitted by the parties by this Thursday. Mr. Clay, when you prepare this order at the beginning, if you could say that this was heard on July 17th, 2023, as opposed to on this day, so that it'll indicate that, so I can tie it back to this particular hearing day. Do we just have so many orders right now? That's very helpful. And make sure you share that with opposing counsel. And Ms. Earhart, we haven't heard much from you. Did you have anything you wanted to say?
Your Honor, not on this issue. However, I filed a motion for summary judgment. There's been requests for admissions, admitted that my client basically had nothing to do with this accident or vehicle. I thought Mr. Clay had said once I had provided an affidavit and all of that, he would non-suit my client, but he hasn't, and that's fine. We were trying to get a motion for summary judgment set for hearing, but for some reason, the clerks had said it didn't need to be set for hearing and that it was going to be submitted to the judge, but I don't know that that's proper.
I think that's a mistake.
Okay.
Did my coordinator or the clerk tell you that?
Honestly, I'm not sure. My office said that it had been placed in front of you and that the docket had indicated that it was before you for review. And of course, I told her I don't think that's proper. I think we're going to have to get a hearing.
Let me look at it real quick. When did you file the summary judgment?
It was filed on June 29th, I believe.
Let's see.
Yeah, my office said the administrator said a hearing was not required. And I guess on July 5th, there was a note from the administrator forward MSJ to judge for review.
I don't know why. So who knows? My coordinator knows that motions for summary judgment have to be set for hearing. So it could be a situation where maybe she misunderstood or something. I don't know, but that does need to be set for hearing. So
Okay, I'll just have my office follow up with the court coordinator and get a hearing.
And
set.
remember that the summary judgments are set through the clerk's office, so just contact the clerk's office and request a hearing date.
Okay, will do.
All right, anything else, guys?
I'll have, Your Honor.
All right, you guys have a great rest of your day.
Thank you, Your Honor.
Thank you, Judge.
Anyone here on Pollard versus Hilti, DC 231979?
That's me, Your Honor. Catherine Allen from Pritchard Young on behalf of defendant Hilti Inc. I
Okay,
don't believe any of the other parties are present.
okay. Then you get to pick the trial date on this. When do you want to set this for trial?
Well, so I came on here to let you know that we've settled our claims.
Okay.
And so I don't necessarily think we need a trial date, but we will need a date for a minor prove-up hearing.
You have you requested a guardian ad litem to be appointed?
We have, and I believe it's Robert Greening who was appointed guardian ad litem. So we're in the
Okay.
process of him doing his ad litem duties.
Let me take a look at this real quick.
And I believe the plaintiff filed a non-suit of the other defendant, Andrew Beard, on Friday.
He's the one that's in jail right now.
That is correct.
Okay, I will go ahead and sign that and forward it. So how much time do we do? I guess has there been any discussion? I guess he just got this case, right?
He recently got the case. The plaintiff has already, or the plaintiff's attorney has already approved the settlement agreement. The annuity has already been funded for the minor. So I think it's
So
just
that's a little risky, but okay.
I know.
Hopefully your judge will approve that.
Yes.
But Mr. Greening does a really good job. So if he feels like it's a good settlement, I usually approve it. So all right, so I'm going to go ahead and sign this order non-suit. What we need to do is put this onto a DWAP docket.
Okay.
So how much time do you think it'll take to, I guess 60 days?
That's what I was going to suggest, Your Honor.
Okay. So the notes on this will say 60 days DWAP, DWOP. All right. I've already signed how did I do this? I've already signed the dismissal on this, the order of non-suit on this case.
Okay.
It looks like. Okay. All right. Anything else today?
That's all, Your Honor. Thank you so much for your time.
Thank you.
May I be excused?
You may.
Thank you.
What was the number on that, Judge?
DC 231979.
Okay, got it. Thank you.
All right. Is anyone here on 4060 Farmers Branch Owner Association versus Wynn?
I am, Your Honor. Jane Cherry for the plaintiff.
Min Wynn, the defendant is on as well, Your Honor.
Okay. Tony, let's go on the record on DC 221927 4060 Farmers Branch Owners Association versus Wynn. Council, make your appearances.
Jane Cherry for the plaintiff.
Min Wynn for the defendant.
Okay. You may proceed.
Thank you, Your Honor. We filed this motion for summary judgment on our affirmative claims for breach of restrictive covenants and breach of contract for an amount past due to our client, the Homeowners Association in this case. At this point, or I guess at the time of our filing would be a better thing to say, Mr. Wynn was in arrears in the amount of $14,423.19. That is past due homeowners association assessments, attorney's fees, and other charges as outlined in the exhibits attached to our motion, and verified by the representative of the association who swore to the business records that they keep, which has the declaration of covenants, I guess like the contract that was breached here, and the covenants that were violated, and showing our lien that's on file for the property, and the ledger showing Mr. Wynn's kind of progress over the last couple of years in getting to this arrearage. And it's pretty straightforward in that respect. We also included an affidavit proving up the attorney's fees component of that amount. And as of today, I don't believe there was a response filed to our motion for summary judgment. And so, I mean, at the conclusion of this hearing, depending on what Mr. Wynn has to say, we would ask the court to conclude that all has, everything that was alleged in our motion for summary judgment be taken as true, and that amount be taken as, uncontroverted here.
Are you asking to foreclose at this point, or are you just asking?
No, Your Honor, we're asking for a judgment in the amount of $14,423.19, and the option to foreclose if it is not paid. So really, certainly the association does not want to foreclose. They just want to be paid the amount of dues and related charges they're owed. But we do include in our proposed order, and we do request in our motion, the right to foreclose if the personal judgment remains unpaid. And I guess, go ahead, Your Honor.
Mr. Wynn?
Yes, Your Honor. First of all, it wouldn't make any sense for me to have a property and not pay HOA. That's the first point. And the amount that was originally supposedly owed is that's the amount that in question. And I have been sending in HOA every month. They just decide not to cash it. That's one point. The second point is whatever the amount supposed to be owed is, there's a process within the bylaw that, mandatory procedures that's supposed to happen before attorneys gets involved, but they didn't do any of that. They just went from, you owe this, here's the notice, we're going to sue you. And I've been trying from the last meeting, last court meeting, I had requested continuance, and it was supposed to happen, next court is supposed to be in August. Next thing I know, I get a summary judgment through the mail and through email for July 17th. I have been trying to get legal representation so that to go to court, but I don't know why it's so difficult, because a lot of lawyers seems to want to represent HOA only and not the actual homeowners. So that's where I'm struggling. But I did find one that agrees to write a letter to the plaintiff counsel around the bylaw and the mandatory procedure to drop the case because of that. But no response back from the plaintiff law firm. So I guess my ask is, I do have ground for the reasons what happened. So I like to have this with legal representation through a lawyer. And I did have I did find somebody to take the case if we're going to do it in August. If I can get a continuance for another court date to take this, have legal representation.
So Mr. Wynn, you've said a lot of stuff there. So let me kind of break it down so I kind of understand what you're talking about, because this, I know this is you've lived this, and I respect that. And there's definitely issues with HOA sometimes. I don't know that there is in this particular case, but sometimes there is with them overcharging and things like that. So you've said a few things here. One is that there's something in the bylaws that requires them to go through a procedure before they file a lawsuit. Is that what you said?
Yes, sir.
And what is that procedure and what did the bylaws say?
So section 16.02 mandatory procedure. They have to give a notice. And then I would meet with them to negotiate. If that doesn't work, we have to get a third party mediation. And then 1606 termination mediation. So, I mean, there's multiple things that has to happen.
Let's, I appreciate you saying that. So Ms. Cherry, was there a mediation that took place? Was this all complied with?
Yes, Your Honor. Yes, there was a mediation, and yes, this was complied with. Those are kind of distinct answers. So we mediated this case pursuant to the court's order. I believe it was in March, possibly late February. And then we appeared briefly for this court's original trial date, which I believe was in March. And then the reason that we complied with the declaration provision Mr. Wynn is referring to, however, is distinct from that. Mr. Wynn emailed me about this on around March 20th, and I responded to him and I let him know that the adjacent declaration provision just before that exempts certain claims from the process he's talking about. So to the extent the court ordered mediation didn't comply with the declaration provision being referred to here, claim for assessments owed is exempt from the process that's being discussed here. That is to cover certain disputes, but not this type of dispute.
Mr. Wynn, is that correct?
I have no idea what you just said. I mean, all the exemption, I'm not aware of it. And a lawyer, a legal did look at this documentation as well. My understanding is whatever disagreement, I mean, the HOA is supposed to be there to protect the homeowner. That's step one. Now, if there's a dispute, regardless of it, I would expect for us to sit down and talk through it and not go straight to lawsuit. Now, whatever is in the bylaw, it clearly says mandatory procedure before lawsuit, but we didn't do any of that. It just went from notice or saying you owe this to straight to going to a lawyer. It doesn't make any sense.
Now, you also said that you sent them checks and they didn't cash them. Is that right?
Yes, sir. And I still do that. They take a picture of it and rip it up. They rip it up and take a picture of it and message it back to me. I don't know why.
Ms. Cherry?
Your Honor, I don't know about the pictures of ripping it up. I personally haven't seen that.
I texted that to you. I mean, I emailed that to you. You've seen it.
I don't know if I've seen that in particular, but I have seen some of the rejected payments that Mr. Wynn has sent me, certainly. And I do.
What right does the association have to reject payments?
Under this particular declaration, the association does have the right at a certain point to refuse partial payments, and that's what they've elected to do here. I understand how frustrating that must be for Mr. Wynn at this point, but they are entitled to do that through the declaration.
Yeah, under the initial O, supposedly O, it's anywhere like $1,000. I mean, initially, and they went to get a lawyer, which cost additional $5,000. I mean, it just doesn't make any sense.
Well, respectfully, Your Honor, I mean, that's not quite a good representation of things. I mean, certainly we sent, before filing this lawsuit, not only were there internal notices sent to the defendant in internal conversations that they would have had without counsel, but I believe we took approximately 3 months pre-lawsuit to send notices and allow an opportunity for this to be resolved without the filing of anything.
Were these payments that were rejected, were they payments made prior to the lawsuit being filed?
Yes, Your Honor.
They rejected payments before the lawsuit was filed?
They did. There's this sort of there's this underlying issue between I'm going to try and describe it. I don't know that it's an issue here, but there's kind of this issue that's adjacent to the one we're discussing here, which is that Mr. Wynn and the developer entered into this, or may have entered into this agreement, this handwritten contract to make association assessments a certain amount for a certain period of time that would have been reduced. And they had a disagreement about that, which led to an approach where they took kind of a hard line in refusing all partial payments to convey to Mr. Wynn that he was incorrect in believing that he owed only partial assessments during a certain period of time.
Your Honor, let me add to that. What she didn't mention is that agreement has the HOA director sign in that document as well. So he's aware of the situation. They just decide not to fix it.
It's really not before the court, and it doesn't address anything that we're discussing here. And the HOA's position has always been that they didn't sign the agreement in the first place. But I do believe it's tangential. It's an agreement that's conditional upon Mr. Wynn doing certain things. And I wish I had it in front of me and I can pull it up, but without a response filed by Mr. Wynn, I didn't. But it was conditional upon certain things being done by Mr. Wynn, and the association has always kind of maintained that it didn't enter into the agreement in the first place and that it was conditional.
All right, let me say things for both sides here. I'm not going to rule on the summary judgment today. I'm going to carry it.
Okay.
So these are my concerns for both sides. One, I have never seen a homeowners association. I used to do this type of, I used to on a pro bono basis extensively. I'm very familiar with this area of law. I've done this. I have never heard of a mandatory association having the right to reject partial payments. That is, it sounds just absolutely unconscionable to me, and I have a serious problem with that. And so I just what I've heard here, I'm very concerned with. It sounds like a property owner association that is trying to bully somebody into I'm not sure why, just bully them and trying to take his house away. So I have some real serious concerns here. Mr. Wynn, from your standpoint, the law is not great for you here. You do need to pay. How much do you think you owe at this point?
I don't know. I'm swagging here, Your Honor. I mean, it's $200 a month. And they haven't, they rejected every check I've sent them, and I still continue to send through automatic bill pay. So, it's been since what, 2019. I'm thinking like 6,000, 7,000. I don't know, something like that.
I understand you're frustrated, and I understand why you're frustrated. How much is your house worth? How much equity?
600.
And how much equity do you think you have in it?
200-300.
Is it? You're fighting over $14,000 here, really $7,000, because you admit you owe about $6,000. I'm just telling you, if they foreclose, they're going to sell this. You're going to probably lose a significant. Hear me out, Mr. Wynn.
Yes, sir.
You could lose a majority, if not all, of the equity in your home. I understand. I don't like how this has been handled by the property owner association at all. That being said, sometimes the better part of valor is to say, hey, I'm just going to pay what you want. And maybe your long-term goal is here to get out of the association and do a short sale or something if they're going to be treating you this way. I don't know. That's my thought. And so, but anyway, I'm giving you some time to try to work this out. We have an August 1st trial setting on this. I would be prepared to go to trial on this. You were going to say something, Mr. Wynn.
No, I'm willing to go to trial with this. It's more of a principle thing, and right now it's.
But the principle is that if you lose this because the law is not good for you, you could lose your house.
I understand, Your Honor. So I just got one question for the Jane, and I'll shoot that through the email. And if I'm wrong on the documentation, then I'll settle, right? And I'll pay what it is. But my point right now is that I'm just following by the bylaw. Now, if the HOA has done everything just like the bylaw is supposed to say, then I'll pay for it because I just want to get this thing done. So But if they went out of compliance and didn't follow the manual procedure, like I think they are, then we'll go, we'll meet on the 21st of August.
I think it's the 1st.
1st of August.
Okay, 1st of August. Okay.
And I'm happy to communicate with you about this via email. I do think that we had an email conversation about that provision you're referring to. From March 20th to March 23rd, we had a little back and forth about why that doesn't apply here. So I'm just conveying that to you as, genuinely, that's my, our position. And I'm happy to talk about it more if you'd like to after this.
Sure.
Well, I'm going to put you guys into a breakout room so you two can talk.
Okay.
Mr. Wynn, you don't want to lose your house over principle. That's what I guess my bottom line is. And I'm going to give you a chance to try to work this out. This is not a fair system for homeowners a lot of times. And this is outrageous to me that they can reject payments from you. That's the type of thing that if the legislature finds out about it, I know how hard it is, how hard property owner associations fight for keeping the right to foreclose. If they're hearing that property owners associations have the right to reject payments like a bank or something like that, then I've fought for years to try to protect property owner associations right to be able to foreclose, because sometimes you have to do it. But this is outrageous to me. Absolutely outrageous that this is in the declarations. And so I would suggest it's in everyone's best interest to work this out. You both have a strong interest to do this. And I hope you'll, Ms. Cherry, speak in the strongest possible way to your client. The judge is not happy with the way this is. And the fact that it sounds like mediation is required. I haven't seen the whole bylaws. If this mediation was required and I determine that, I'm going to bait this case until mediation is done.
Well,
If that's the case.
Respectfully, we did mediate the case.
But you didn't mediate it
We
before.
did pursuant to your honor's order.
You didn't mediate it before filing suit.
Not before filing suit, but the declaration really is quite clear that an assessment dispute is not the type of dispute where they're mandating a certain pre-suit.
That is your position. So, but this is something that needs to be worked out, Mr. Wynn. Standing on principle could be a huge mistake. I don't like what the homeowner association has done. We'll see you at trial on August 1st if you can't get it worked out, but I strongly urge you both to work it out.
Well, Your Honor, during mediation, I agreed to pay whatever I owed, but not lawyer's fee. They didn't want that.
I think you're going to have to pay some lawyer's fees on this. I think that how much lawyer fees do we have at this point?
I believe it's a little bit less than 10,000, Your Honor. But I think the association would be agreeable to, some kind of partial payment of those just to put this behind them. It's not money that, we're seeking. It's money that they've already paid to us is the tricky part about it. So it's not anything I have any control over anymore. It's actual costs that the association has incurred. And I'm not sure, why they took the approach that they did in the partial payment treatment. And I wish I could speak more to that in their defense, but it is a little bit unusual. But I just wanted to say that it's not something that we kind of, that we urge them to do as part of this dispute or anything like that. But it's something that they do have the right to do under their documents. And I'm not sure, like Your Honor mentioned, it is a little bit unusual that you see that in these types of.
There's a lot of things unusual in these documents that I've not seen before. And so, but Mr. Wynn, you're standing on principle can lose you a lot of money. I'll just say that I've seen that many, many times in my court. So if they're willing to cut their attorney's fees to a reasonable level and you have to pay part of them, that's a lot better than losing your house. That's all or losing your condo. Is this a house or a condo?
Townhouse.
Given the value of it. So, But I'm going to put you guys into a breakout room. I hope you guys can work everything out. And otherwise, we'll see you on August 1st.
Thank you.
Thank you, John.
Thank you, guys. Bye-bye. So go to the breakout room, please. Oh, this has been a busy morning. Is anyone here on Smith v. Smith?
Yes, Your Honor. Both attorneys for the plaintiff are here, but I don't see the defendant's counsel on.
Okay. All right, it's not quite time yet. All right. Tony, why don't you take a quick 5-minute break and we'll reconvene at 11. Interns, you guys can take a break. If you guys need to leave to get to our lunch location, go ahead and leave. You know, I don't know how long it'll take you to get there. And I will get there. I may not get there by noon, but I'll get there as soon as I can once these hearings are over.
Judge, am I going to lunch?
Oh, I guess you can if you want to.
I mean, totally up to you. I don't, either way.
It's yeah, why don't you stay on and I'll tell you what the lunch is and
Okay.
you can decide if you want to go. I'll be right
Your
back.
Honor, I see defense counsel is joining now.
Okay, yeah, okay. We're gonna reconvene in about 2 minutes.
Please wait to be assigned. Oh, I see. Oh, fuck. Oh, I guess not. No, there I am. Yep.
All right, let's go back on the record. Tony, are you there?
Yes, Judge.
Let's go on the record on DC 21-15113, Smith v. Smith. Counsel, make your appearances.
Cynthia
Your Honor,
Rigney for the plaintiff. Sorry.
that's okay. And Matthew Rigney for the plaintiff also, Your Honor.
John Nation for the defendant, Trent Smith.
All right, let's proceed.
So, Your Honor, we had filed a motion to strike the affidavit attached to the defendant's response to the summary judgment. This was something we discussed at the hearing on June 30th when the court reset this. So I presume the court would like to start with that.
Okay, go ahead.
So as the court knows, this is a case about the proceeds of the sale of a house that defendant owes to plaintiff. The defendant and the plaintiff here, my client Frederick is the plaintiff, defendant is Trenton. I'm going to refer to them by their first name since they're both Smith. Frederick and Trenton were parties to the sale of a house with 4 total parties to the sale. The sale was for $100,000 gross proceeds. And it seems like all the parties here agree that each party was due $25,000 gross, which after deductions for taxes, closing costs, things like that, came out to be $22,875.10. So that's kind of what we're talking about here. The plaintiff filed our motion for summary judgment in May, I think, maybe April. No response was filed until a couple weeks ago when we were before the court. And then we had moved to strike the responses late. The court granted the plaintiff's motion, it appears, to file the late response. And this motion to strike is about an affidavit that was attached to that late response. Plaintiff's moving to strike the affidavit on, I guess there's 3 broad bases. First is the affidavit concerns testimony of facts that are directly responsive to discovery responses, to discovery requests, to which the defendant has not responded. The discovery requests were propounded on March 24th. They were due in April. Counsel for the defendant requests an extension on April 20th until May 15th. No responses came on May 15th. We followed up on May 16th with counsel for the defendant. There was never a response to that follow-up, and to date, their discovery responses have not been filed. So we're moving to strike the affidavit under Rule 196.3. The affidavit itself contains testimony about the amount of money that defendant claims is due to the plaintiff, and then whether or not that amount of money was repaid. Paragraph 4 of the affidavit specifically admits that my client Frederick's share was the same as everyone else. He was due $22,875.10, and that he asked that the funds be wired into the defendant's bank account. Then the affidavit goes on to say, after settlement charges, closing costs, payment to other family members whom the plaintiff owed money, and payment of the past due property taxes, Frederick's share came to $49.91 and 91 cents. This information, these facts are directly responsive to interrogatories that were propounded in March. Interrogatory number 8 asks the defendant to identify each and every date and location which you allege or delivered a portion of the monies in question to plaintiff. Interrogatory number 9 asks the specific amount of monies to be repaid, and 10 asks if it's anything less than the $22,875, state the basis for that calculation. The portions of the affidavit I just read to the court are directly responsive to interrogatory 10. The second paragraph 5 of the affidavit claims that the money was repaid, but it doesn't say where, when, why, how. So it's kind of, partially responsive to interrogatory number 8. And then along with this interrogatory, we also propounded request for production. It was only 2 requests. One was documents to support the response to interrogatory number 8, which is when, where, why, how did you repay? And then there are some bank account records with checks. Then we asked for images of those checks. None of that's been provided. And so here, the defendant's using, this affidavit to avoid summary judgment when this information is directly responsive to interrogatories and requests for production that have never been produced. So that's our first basis for striking the affidavit. The second basis, Your Honor, is, generally under Texas common law.
Can you share screen the affidavit, please?
Yes, I will. Yeah, Your Honor.
Next page, please.
So this paragraph 4 is the one I was referring to. And then also the second paragraph 5. So unless the court has any more questions about that kind of basis for striking the affidavit, I can move on to our second point. The second point is the affidavit's conclusory and self-serving, and it doesn't provide any factual basis for its conclusions. The motion points out to several paragraphs here, but I really want to talk mostly about paragraphs 4 and the second paragraph 5. Paragraph 4 admits there's an agreement, admits that Frederick's share is $22,875, and there was agreement to deposit the funds. However, it refers to other money he owed, the plaintiff allegedly owed to family members. This is essentially other contracts that exist out there that the defendant claims he reduced Frederick's payment before he paid him back, if indeed he paid him back. These other agreements, they're not attached to the affidavit. There aren't affidavits from those other people. And there's just no basis for the calculation. Again, they're directly responsive to the interrogatory we propounded, but they're just put out there in the affidavit without any support. I would assert that under Rule 166 AF, which requires that, papers referred to in affidavits, sworn copies be attached to the affidavit. This is direct reference to other contracts with other family members that aren't attached, aren't supported. It's just claims that are frankly conclusory and self-serving to the extent that he relies on them to avoid summary judgment.
Yeah, I get it. Response.
All right. Your Honor, on the motion to strike the affidavit, as far as the discovery goes, we've been trying our best, and our client has not proved to be cooperative in that endeavor. And we have some responses, but if we serve them on plaintiff right now, they would be justified in saying we hadn't answered them. So that is the reason for that. As far as conclusions and self-serving, our affidavit is no more self-serving or conclusionary than opposing counsel's affidavit. This is an informal family arrangement where nobody made or signed a written agreement as to what would be the disposition of the money. We don't dispute the money was put into Mr. Trent Smith's account. But as we showed in our affidavit, that he received a smaller share because he had been living in the house without paying the property taxes. And that was deducted from his deposit, and that's why he received less money than the other relatives. Unfortunately, nobody kept receipts, and so I believe that they have not shown their entitlement to summary judgment, and this is just a case that's going to have to be tried on the fact issue of whether a deduction was made and why it was made, and those issues, Your Honor. Thank you.
I mean, I agree with you. Unfortunately, I don't think summary motion to strike is appropriate. I don't think summary judgment is appropriate, unfortunately. But I do think you need to answer discovery. I just want to tell you that your approach right now is if you come to trial, if they move to compel on this discovery and that's your response, your client's going to get sanctioned, and so
I'm sure you will.
You need to tell them they need to respond to discovery. It would seem that a lot of this should be resolved by looking at your client's bank account. I mean, he got money in, it would detail the money going out. If he made a loan, I assume he wrote him a check. Maybe he gave him $3,800 in cash. But there's a way to track at least some of this stuff through, I assume, bank accounts. That's the logical thing to me that's here. But what we have today is a summary judgment and a motion to strike. Both are denied. Do we have orders on this?
Yeah, I apologize, Your Honor. If I could just quickly speak to one of the causes of action that we have, because we think summary judgment would be appropriate as to the cause of action of conversion. If I could just quickly explain our position on that. The parties concede that the agreement was made to transfer the funds into the defendant's account. The defendant concedes that he received them. We attached the bank records as evidence that he received the wire transfer. We've asked for discovery, pointing out when did you pay him back? Where did you meet? We've submitted evidence from our client showing that he sought to meet with the defendant to retrieve the funds, and the defendant essentially ignored every single attempt from our client to communicate with him. For conversion, what we have to show is that the defendant had the funds. They were intended to be for safekeeping, intended to be kept segregated. We've shown that they were deposited into the defendant's account. And the last element is that they're not subject of title of claim by the keeper. So to the extent that Trenton is saying as part of his defense, well, part of the money was supposed to go to these other people, that's not his claim of title. So to the extent that he says he retained these funds for other people, he still has not disputed any element of the cause of action for conversion. He's shown that he was supposed to keep the money for safekeeping, and he has not asserted that he had a claim to the funds. He claims other people had a claim to those funds, but he also has not established that our client gave him the authorization to pay those funds to other people. So we do think that we've established summary judgment basis for the conversion cause of action. At least, and the other item that we would put for the court is, to the extent that he claims I received the $22,875 and I paid him back $9,400 and change, there's still about $13,000 that he hasn't explained why he hasn't given it back to our client. So to the extent he claims that those $13,000 were supposed to go to other people, it was the responsibility of the defendant to give those to the plaintiff for him to pay those back. So we would submit that we're entitled to summary judgment on conversion, and at least as to the $13,000 that's in dispute.
That's not in dispute.
Sorry, that's not in dispute.
Yeah, I do think it's in dispute. I think maybe that was a Freudian slip, but yeah, summary judgment's denied on that as well. Okay, guys, thank you so much. Get me an order on that, Mr. Nations.
I will.
Should say that this was heard on July 17th, 2023, and share the copy of the order with Mr. and Ms. Rigney, and get me a copy of that order by this Thursday.
Will do.
Thank you. You guys have a great rest of your day.
Thank you, Your Honor.
Thank you, Judge.
Okay. Let's go on the let's see, are both sides here on the Spencer versus Basharian case?
Judge, I'm here on that one.
I'm sorry, say that again?
Judge, it's Jeff Clark. I'm here on the Spencer case. I don't
Okay.
see the opposing counsel. We've been called to trial for tomorrow. So I'm not sure whatever the court does on this motion to quash we're supposed to go to trial tomorrow. So, I mean,
Are you guys ready for trial? I mean, is it,
I've announced ready. Yes, sir.
and yeah. It's interesting. This is a pretty new case. We have 3 pretty new car wreck cases that all of them appear to be ready. We'll see. Let me see if we've got anything new in on them. Right now, you're number 3, which, oh, no, one of them just settled in front of you. So the number 1 case is gone. The number 2 case, there's no indication that it's gone. Oh, there's somebody here just showed up for your case.
Sure.
Looks like at least at the moment, you're number 2 on the docket.
We're planning on being there tomorrow morning.
All right. Miss Kim, are you here on the Spencer case?
I am, Your Honor.
All right, Tony, let's go on the record on DC 22-15199. Spencer v. Basharian. Counsel, make your appearance.
So Jeff Clark for the plaintiff Spencer.
Sophia Kim for the defendants.
All right, we're here on a motion to quash.
If the court please, we're set for trial tomorrow. The written deposition questions this time were sent out about 3 weeks before this trial setting. So they were sent out within 30 days of trial. So we've filed a motion to quash, saying they were sent out after the discovery period closed. This is the second time we've heard a motion to quash. The last time the court granted them leave to send out late discovery request, but this time we're set for trial tomorrow. And we'd ask the court to enforce the discovery cutoff in this case, which was about 30 days ago. And
What I would suggest we do on this one is I was telling Miss Kim, this is your case.
Yes, Your Honor.
So this case there's a very good chance you guys are going to trial tomorrow. You've gone from like number 10 on the docket to number 2. I don't know what the number 1 case is going on with them, but there's a very good chance you could go to trial tomorrow. So are you guys ready to go?
Plaintiff is.
Defendant is not, Your Honor. Based on the medical that we did receive from the last motion to quash, that was denied. There have been some developments in the records that we did already receive. We believe that the additional records are necessary in our defense. The plaintiff's testimony is in direct contradiction to her medical records. The additional records that we have requested, unfortunately, there was a missed email from our record retrieval company. And so they were not able to request these records that are at issue at the same time that the UT Southwestern records were requested. But if Your Honor says that we are called to trial tomorrow, we can be ready with the information that we have. We would request a reset in order to get the additional records to properly prepare a defense. But again, we're at the court's mercy.
You know, Mr. Clark, this case is relatively new. If you want to agree to a reset, I'm happy to do it. If you don't agree, then you guys will need to be ready for tomorrow.
From our standpoint, Ms. Spencer's deposition was taken 3 months or so ago. We're ready to try the case. She's finished her medical treatment. The case is ready to go to trial. So the case has been mediated.
Well,
Yeah.
Is there, I mean, have you guys tried to settle this? Is this close to settlement or?
We
Which-
have tried to settle, Your Honor, but it's not close. There's a liability dispute.
You want me to give you the name of the the current number one case? It keeps changing. I can give you the cause number and the attorney's names if you want them.
Thank you, Your Honor.
It is Marino versus Carmona. Marino is Merino versus Carmona, Carmona. It's DC 228013. I imagine you guys will know the plaintiff's attorney. It's Nathan Majors. If you all know him. And then I don't know the defense attorney. It's Sheris S.
She's with Geico.
Okay, Sheris Hodder.
Yeah.
Y'all need phone numbers for them, or do you already have them?
I'm good.
Could I get defense counsel's number, Your Honor?
Sure. It is 972-855-6400. And her cell is 972-701-1722. And just so you may want to let her know that they are number one now. They may not know that. My coordinator's out today because she's at a conference. And so if they've called in to tell us anything, right now they're number one.
Well, Your Honor, could we just hold off on the ruling on the motion to quash to see if we actually do go to trial tomorrow? Otherwise,
yeah, I mean, I'm inclined. Yeah, I agree. I'm inclined if the case doesn't get reached tomorrow, then you guys, I'd probably deny the motion to quash and let the discovery go forward. But I'm not going to move the trial setting for it.
All right, fair enough. Thank you, sir.
All right, we'll see you guys tomorrow.
All
thank
right.
you, Your Honor. May we be excused?
You may.
Thank you.
Tony, we'll see you at 1:30. Alexis and Rob, we'll see you at noon. And Isabella, that was a lot of notes to take, wasn't it?
I got it all.
All right, so I'm going to want you to type up all of that and email it to me. Alexis and Rob, you guys can head out.
What do you want to put for that last one?
Nothing.
Okay.
You don't need to do any notes on it. It's just they're going to be at trial tomorrow. So yeah, if you could try to get that to me this afternoon, the afternoon hearings, it'll be a lot easier because you don't have the dismissal docket. That's most of your notes. So type them up, send them to me. I'm going to cross-check them with my notes, and then we'll send them to Rhonda. But just what I want you to do is just put it into a Word document, or not a Word document, into an email, and just with the very like DC 2309285 30-day reset, DC 233509 no show, and I'm going to cross check it if it's all good, but I want to be able to edit it if there's something I see different in there, and I'll forward it to Rhonda.
Okay. Do you want me to go to the lunch or to just stay?
No, do you want to go to the lunch?
Yeah.
Yeah.
Yes.
Kirkland is kind of interesting because they're so over the top fancy. They're this really hotshot firm from, I think, Chicago that all the other firms are kind of nervous about because they pay people so much money, and anyway, it's kind of an interesting deal. So it's an interesting lunch. It was an interesting lunch last year.
Okay.
So all right, we'll see you there.
See you then.
And Judge, I have a dentist appointment that I completely forgot about, so I can't come to the lunch today.
Okay.
But I will see you on Wednesday morning.
Wednesday morning. Oh, you're not going to be here this afternoon?
No, because of the dentist appointment.
Okay. I'll see you on Wednesday.
Okay, perfect.
Oh, text me first because I may I may not be going in if our trials are over. So just text
Okay.
me in the morning or Tuesday night just to ask
Okay.
me, are we still going, do I still need to show up?
Perfect.
We do have lunches Wednesday, Thursday, and there's a breakfast and a lunch on Friday and hearing. So we'll just talk about it.
All right, perfect. Thank you so much.
Okay.